Hello everybody, I am Yogesh Pai, Assistant Professor of Law at National Law University, Delhi. Today we are going to discuss Introduction to Intellectual Property, a conceptual primer. The outline of this course basically has to deal with basic concepts involving intellectual property, the nature of exclusivity provided, the principles of alienability and nature of remedies, of course. We are also going to discuss classification of intellectual property rights into separate categories involving patents, copyrights, trademarks, geographical indications, industrial designs and other sui generis legislations. We are also trying to give an explanation on each of these categories involving intellectual property rights and some of the technical concepts involving the same. We also will discuss the differences between real property or tangible property in the sense of land and chattels and its distinction and the features that distinguish it with intellectual property rights. Finally, we will conclude with the structure of the course as to how the course will proceed in the next few months, and we will discuss the summary. Intellectual property has its basis in property concepts. So property, as you generally understand, can be divided into land, chattels and other kinds of intangible properties like shares, of course intellectual property also. So when you talk in terms of land and chattels, these are what are called as real property or movable and immovable properties, and intangible in the context of intellectual property is a specific right. Now what is property? Property in real context is a bundle of rights, and we are going to do a bit of explanation on these property concepts. But before that, why do we need property? Can't contract law, tort law or other kinds of acts that can remedy unfair competition protect or incentivize creativity or inventions? The difference between property and all these other categories of legal mechanisms has primarily to deal with the nature of remedies. The nature of remedies provided in a property right is in rem, vis-a-vis the nature of remedies provided in other categories is in personam, in the sense that if you have a property right, it applies against the world, but if you have one of these contractual rights or an action under tort law, it may be vis-a-vis a person. So specifically property rights provides you a broad ambit and scope to deal with various kinds of activities involving protection of invention and creativity against the whole world in general. So property as a bundle of rights primarily has two components. It is the right to exclude and the right to alienate. Now if you understand right to exclusion, it basically has to deal with your right to exclude others or third parties from making, using, selling, reproducing, importing, offering for sale, distribution, and concept of right to alienate includes the specific rights relating to sale, distribution and transfer, right. So both these, exclusion and alienation, are the two core components of rights involving property. The core of property also involves remedy or remedial actions. They are in the form of injunctions, damages or accounts for profit, and these may be both retrospective or prospective and sometimes exemplary. So why property based protection is important for creating incentives? Is there an argument for economic efficiency when you compare it with other forms of mechanisms? And when we say other forms of mechanisms, they primarily involve subsidies, prize funds or basically prizes, tax breaks or publicly funded research and development that is carried on by the state. How are these mechanisms different from intellectual property protection or a property based protection? Now primarily property rights are important, or the role of property rights becomes central to governing innovation and creativity due to its perceived economic efficiency, vis-a-vis all these other alternative systems that incentivize or that may incentivize creativity and innovation. This can be classically explained through concepts like property versus liability. In a property system, the entitlement that the IP owner or the intellectual property holder has to receive is determined by the market, because market forces will actually decide how much of remuneration should go back to the IP holder once the product is put by the IP holder in the market, and given that it is protected by law. But in case of liability rules, the entitlement that the inventor or creator should receive is decided by some third party. So in all these alternative systems like price fund subsidies, publicly funded R&D, how much it takes to incentivize or how much it takes to foster creativity is decided either ex ante or ex post by some external agency, which may not be in a proper position to decide on the value of entitlement. So ultimately, because the value of entitlement is not decided by the market forces, these other alternative systems may be deemed less efficient when compared to property rights system. Having said that, what is intellectual property? Intellectual property is of a recent coinage. In fact, the predecessor of the World Intellectual Property Organization in around 1960s coined this term to include broad categories of industrial property and copyright. Traditionally, intellectual property as a system has developed through these two systems, industrial property and copyright. Industrial property included patents, trademarks, industrial designs, geographical indications, etc. And copyright involved or was based on authorship, and it also included certain kind of entrepreneurial works like sound recording, broadcast, which are also called as neighboring rights. So why are these two systems distinct? This has its roots in a bit of history. History tells us that copyright was more concerned with authorial creativity, and it has some connection to being expression of your personality. So it was considered distinct from trade and commerce, while other forms of creativity is expressed through technical inventions or through industrial designs, and in certain cases the requirement that your mark be protected or your geographical indication be protected was in relation to trade or commerce. That is why it was classically called as industrial property. We also have certain sui generis legislations. These are the kind of laws which are specifically enacted so that the existing traditional categories like patents, copyrights, trademarks, industrial designs do not actually provide sufficient basis for protection, and that is why certain of these aspects of creativity are to be protected by a different indigenous kind of law, which means it is a sui generis legislation. So these are protection of layout designs, what are also called as semiconductor chip designs, and also plant variety protection. There are other kinds of laws that provide IP type of protection, but there is larger dispute whether these amount to intellectual property rights in themselves. Nevertheless, we for broad purposes include them within the category of intellectual property. They are the common law action of passing off and unfair competition, certain kinds of protection that are needed for protecting trade secret and confidential information. We also provide data exclusivity for test and other regulatory data that is usually submitted to the governments. Some countries also provide protection for non-original databases, and we will discuss along with this a bit of personality rights, and we will discuss these in the next slides.